The contracts question from February of 1991 is one of the least popular essay questions that I've ever encountered on any bar examination, and I have personally met a number of candidates who failed the February 1991 bar exam because of this question. Now, once you've had a chance to review it with me, you'll see how there is a magic key that unlocks this fact pattern, and anybody who put their hands on that key got a passing score, and those who did not failed. And it's an easy lesson. Once you hear it, you will never forget it, and you will be sensitive to the issue if you see it on your bar examination. And it's an issue that I pointed out during our introduction to an approach to contracts. Have a look at the call of the question. What legal arguments could data raise as defenses, and how should the court rule on each of them? Discuss. Well, if you paid attention to the approach, you saw that a defendant can offer defenses at several different stages of a contracts analysis. And this fact pattern calls on us to interpose all of those possible defenses, and maybe even one or two that are a little specific to these facts. Go to the top of the question, and let's review the fact pattern together. In paragraph 1, we find out about Tech, who turns out to be our plaintiff. And Data is a supplier and an installer of research equipment for a floating research station in the mid-Pacific Ocean. In paragraph 1, we find out that other sellers are available on the market, but that only Data is capable of installing the equipment. In paragraph 2, we've got an offer from the president of Data to do the job for $28,000 by July 30 of the following year. An important fact to keep in mind, always keep track of the dates, and Tech accepts. Then on April 4, Tech sent Data a confirming letter with regard to the April 3 negotiations. A month later, in paragraph 3, Tech calls Data to ask if the work could be completed by May 1 instead of July 30th, so that Tech could participate in a Navy experiment, and the representative of Data says that the work can be completed by that earlier date with no additional charge. That's apparently a modification to the agreement, and it raises yet another rather technical and extremely important issue. In paragraph 4, we see Data signing a lucrative contract with a major oil company, and then on June 1, Dan informs Tech that Data will not be able to install the air quality monitoring equipment, and that installation aspect was at the heart of the agreement from Tech's perspective. In paragraph 5, we see the lawsuit. Tech looks to cover, can't do it, and so sues Data in State A for specific performance, demanding that Data be required to supply, install, and test all of this equipment by May 1, 1991. And then the call of the question again. What legal arguments can Data raise as defenses, and how should the court rule on each of them? Discuss. Well, we're going to represent the defendant for a change in this fact pattern, and we will represent that defendant with some vigor and zealousness. Have a look at the outline of issues that I present, and you'll see that I offer defenses to formation, to the modification, to the breach, and to remedies. And that is the magic key that unlocks this fact pattern. Candidates who spent a lot of time doing an offer acceptance consideration boilerplate style approach to contracts were left in the cold, not because they were wrong, but because they didn't really have time to finish. As we work our way through my answer to this question, you'll see that I do cover those bases, but I present the entire answer in the context of the defendant's defenses. And that is what is central. My answer to this question is exactly responsive to the call of the question, and it doesn't neglect the various important aspects of contracts law that are required for a full analysis of this fact pattern. So look at my outline briefly, and you'll see that my primary defense to formation is the statute of frauds. We've got performance that is required later than 1 year, and we've got a defendant who never signed a confirming letter agreeing to the contract. Next, we talk about the modification. And notice that I talk about how not only does this modification lack consideration, but it isn't in writing. And one implicit question here that's kind of difficult to come up with a straight answer to is, what law governs? This is a contract that would appear to be a UCC agreement for goods. But notice that although the installation aspect of the deal is less than 1/3 the purchase price, it is still essential for the buyer to obtain delivery in order for the contract to really mean anything. So we'll talk about this modification. Next, the only defense to breach that I can come up with was that the plaintiff's lawsuit is premature. And that's a pretty lousy defense to breach, as we'll see when we get to a review of this section of the answer. And then finally, I focus on defenses to specific performance. The first argument, legal remedies are adequate, and we're going to see they're not. And then, interestingly, I argue that the court lacks jurisdiction to order performance, and the reason for that argument is that allows me to find a home for the fact that the installation is supposed to take place in the middle of the Pacific Ocean. It would be a very different story if the installation was supposed to take place at the terrestrial campus of the university. Next, I suggest that the contract may be for personal services, for the installation aspect at least, which would be another bar to specific performance. Ultimately, I reach a conclusion. So most candidates either passed or failed this question before they wrote or typed the first word of their answer. This was a fact pattern that cried out for careful outlining. And as you look at my outline, you'll see that it is not terribly elaborate. It doesn't go into nearly as much detail as many other outlines of mine that you will read in connection with this class. But what it does do is it allows me, or any writer, to come up with essentially a series of short answers to very specific inquiries. So let's take a look at the answer for a few minutes and maybe you'll see what I mean. Look at the very first paragraph that I write. I lead with the facts, and I then turn to the defense to formation. Notice that I do work in the facts about offer and acceptance pretty much up front. All of those details from the negotiation do find a home in my answer, but I present them in the context of defenses. So we focus on the 1-year rule, and I point out that I think a fairly useful point, which is that the statute of frauds applies only to contracts that can't be performed within 1 year. Here, in this contract, the date is a deadline rather than a requirement, and that could very well take the statute of frauds out of contention for being a defense to formation. Perhaps a somewhat more convincing argument defending the existence of a contract is that the defendant failed to sign a confirming letter. The problem with that is that to the extent this is a UCC agreement, UCC section 201(2) would be good enough to bind data, since data did not object within 10 days of receiving the confirmation note. So ultimately, I conclude that data is going to be bound to the terms of the agreement because the letter satisfies the statute of frauds for a sale of goods between merchants. And so I conclude that a binding contract has been formed. Next, we turn to the modification. Here, once again, the very first thing I do is I lead with the facts. I make reference to the telephone conversation, and I indicate right up front that the court isn't going to enforce the modification. The two arguments I make: first, the modification lacked consideration, which would have been required under the common law, and it isn't in writing, which would be required under the UCC. So here, not only do we need to know two different bodies of law, but we need to apply those two different bodies of law to one set of facts. And I think the fact that this question is dealing with a contract that has aspects of UCC and aspects of common law is one of a number of features that make this fact pattern so difficult and so unpleasant to try to dissect. In the end, I conclude that the modification is unenforceable. Next, we turn to probably the weakest of the defendant's arguments, which is that the suit by the plaintiff is premature. The argument being that the plaintiff should have waited until performance was due to file suit. The problem with that is that the law of anticipatory repudiation gives the non-repudiating party a lot more rights than that. A party who has been the victim of a contract repudiation has got a choice. That party can sue now, that party can wait until performance is due and then sue, or they can seek further assurances. Here, the bottom line is that Tech was well within its rights to sue Data immediately after making an effort to secure cover performance. Finally, we turn to the defenses that the defendant will offer for specific performance. And here, the defendant has got somewhat stronger arguments than the earlier arguments. Notice that we're going to conclude, despite the defendant's best arguments, there is a valid contract, and the defendant has successfully defended against the modification. But the modification only deals with the date for performance. It doesn't deal with the essential requirement for performance, and so that defense isn't going to help the defendant very much here. So now we turn to specific performance. Up front, I argue that obviously Data has breached this agreement by anticipatory repudiation. The only remaining question, can this defendant escape being ordered to perform? Ultimately, I conclude that it will not, and that the plaintiff in fact is going to win, both under the breach theory and for specific performance. So take a look at the arguments that I make. First, I argue on behalf of the defendant that legal remedies are adequate. The problem is, the facts show us that they obviously are not adequate, because although there are alternative suppliers, there are no alternate delivery agents. And that makes legal remedies inadequate. It doesn't matter how much money we order this defendant to pay, it won't be enough to get the plaintiff the benefit of its bargain under the agreement. Next, I argue that the court lacks jurisdiction to enforce a specific performance order involving delivery and installation halfway across the ocean. The problem with that defense is, even though the court may not have in rem jurisdiction over the delivery location, it already's got in personam jurisdiction over both parties, and that ought to be good enough to make a contempt citation something with enough teeth in it to bind the party. Certainly the court is not going to be called on to monitor the installation in the middle of the ocean. Finally, the last argument I make is that the contract is one for personal services. And although it is true that the delivery and installation component technically is not a UCC agreement, it's also not such an intimate type of personal service, for example, requiring an artisan to create a work of art for a defendant, or to require a servant to come back to service for a boss that the servant decides he or she doesn't like anymore. The personal services argument is one that I take a couple of paragraphs to play out, but I argue it too will fail, and should fail, because the delivery is much less of a personal service than it is a way to facilitate the UCC aspect of the agreement. The defendant had a valid contract with the plaintiff. The defendant has breached by anticipatory repudiation, and I see no facts present that make me any more sympathetic to the defendant than the plaintiff is. The motivation for the defendant in breaching was to make a lot of money in a private contract with an oil company. Certainly, there are no compelling reasons why this defendant should escape a finding of breach and an order of specific performance.